Mr. Young's.
No.
Oh, what's up? Hey. Good to see you. No, he's on the beach. Yeah. Or,
You may have it online or in world, but
Okay, can you hear me?
Yes, Your Honor.
Robin Rachel Balling.
right up to the table there.
I'll wait till you.
Are you Robin Rachel Balling?
Yes, ma'am.
Okay. On the record in the matter of the people of the state of Michigan versus Robin Rachel Balling, counsel appearance, please.
So thank you, Your Honor. Assistant Public Defender Sarah Donnelly on behalf of the defendant who is appearing from Lansing Police Department for the purpose of arraignment only.
Thank you, Mr. Balling. Today's the date that's set for an arraignment. And I have before me a misdemeanor complaint. It alleges that on or about May 20th, 2022, at the area of 2008 Turner Street, City of Lansing, Ingham County, State of Michigan, that you did allegedly contrary to law commit the act in count 1 of domestic violence. It alleges that you did make an assault or assault and battery upon a Andrew Ibarra, a resident or former resident of your household, or an individual with whom you have a dating relationship, and that this was done contrary to Michigan Compiled Law 750.812. This is a misdemeanor. Maximum penalty is 93 days and/or $500 in fines. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Restitution is also likely, as this offense may have resulted in damage to another individual's property or physical injury or death to another individual. Do you understand the charge there, ma'am, and the maximum penalty attached to that charge?
Yes, Your Honor.
Okay. You have the right to be represented by counsel. You are represented by Ms. Donnelly today for the purposes of your arraignment only. But you have the right to have an attorney with you at each stage of the criminal prosecution. And you have the right to request court-appointed counsel be appointed if you cannot afford to hire your own attorney. Do you understand that?
Yes, ma'am.
Is she requesting court-appointed counsel?
Yes, Your Honor.
Okay, Ms. Balling, you have the right to remain silent. Anything that you say, anything that you put in writing can be used against you. You have the right to plead guilty. You have the right to plead not guilty. You have the right to stand mute and continue with the criminal prosecution. You have the right to proceed to trial on this matter, and you have the right to have a jury trial. At the time of trial, you have the right to have the prosecution prove each element of the charge against you. They have to prove each of the elements beyond a reasonable doubt. Do you understand that?
Yes, Your Honor.
You have the right at trial to remain silent and not have silence be used to prove or implicate your guilt. You have the right at trial to cross-examine or question any witness that the prosecution intends to call. You have the right to call your own witnesses or present evidence that you believe would further a defense to the charge. And then you have the right to be presumed innocent until proven guilty beyond a reasonable doubt. Do you have any questions about those rights?
No, Your Honor.
Okay, you also have the right to have an attorney with you if you are going to be questioned or interrogated. Currently scheduled for a pre-trial before Judge Cynthia Ward via Zoom. It's going to be June 14, 2022 at 9:30 in the morning. Did you get a copy of your notice indicating that information?
Yes, I did, Your Honor.
Okay. For the purposes of her arraignment, is she pleading not guilty?
Yes, Your Honor.
Thank you. Ms. Bowling, where do you reside?
I will be staying with my daughter in Flint, Michigan, at 433 Daughtery,
Can you spell that?
Daughtery, Flint, Michigan, 48504.
Okay, are you currently employed, ma'am?
No, Your Honor.
What's your phone number?
517-488-1559. So.
Charlie, did you want to address bond?
Thank you, Your Honor. I know Ms. Bowling from a previous case. She's had a couple through your court. She has no failure to appears on those cases. She was able to successfully stay with her daughter in Flint during those cases. So I have no reason to believe that she will not appear. And she didn't have any, I don't believe there are any, from my understanding, there wasn't any violations of no contact either. She was able to honor that as well. So at this time, I would request a personal recognizance bond with the standard conditions. Thank you, Your Honor.
Now, you don't see that previously, copy of fight. If a family dollar 99 left, people standards are calling about a white male and white female fighting outside of the store. Usually for over either in South Carolina. Okay, thank you.
Okay, I grant the request for a personal recognizance bond. There will be a no contact order in place. Ms. Bowling, you're not to be within 1,500 feet of wherever Mr. Andrew Ybarra is. Do you understand that?
Yes, Your Honor.
You're not to be present or reside at the address of 2008 South Turner Street. I have here that you will be residing with your child at 433 Daughtery in Flint, Michigan during the pendency of this matter, okay?
Yes, Your Honor.
Also, while on bond, you need to make sure you appear to court for all of your future court dates. You need to appear on time. You're not to engage in any assaultive or threatening behavior. You're not to travel outside the state without prior approval of the court. You're not to use, purchase, or possess drugs or alcohol unless you have a valid prescription. You're not to have any contact directly or indirectly with Mr. Ybarra. Do you understand that?
Yes, Your Honor.
You're not to possess a firearm or any other dangerous weapon. Do you have any questions about your bond conditions at this time?
No, Your Honor, I do not.
Okay, bond will be set again at 1,000 personal recognizance. Any additional matters before the record?
No, Your Honor, thank you.
Thank you, Your
You're all set,
Honor.
ma'am. You're welcome. Maddie Horton.
All the way up.
On the record in the matter of the people of the state of Michigan versus Maddie Lee Horton. File number is 22-01265FY. Council appearance, please.
Thank you, Your Honor. Assistant Public Defender Sarah Donnelly on behalf of the defendant, Maddie Horton, who is appearing from the Lansing Police Department for the purpose of arraignment.
Thank you. And you're Miss Maddie Horton?
Yes,
Okay, Ms. Horton, I have before me a felony complaint. It alleges that on or about November 30th, 2021, in the area of 918 Pierce Road, which is in the city of Lansing, Ingham County, state of Michigan, that you did allegedly contrary to law commit the act in count 1 of home invasion first degree. It alleges that you did break and enter or did enter without permission a dwelling located at 918 Pierce Road, which is in the city of Lansing, and while entering, present in, or exiting, did commit a larceny, and while entering, present in, or exiting the dwelling was armed with a crowbar, which is a dangerous weapon, and Shataya Walker was lawfully present therein. This is contrary to Michigan Compiled Law 750.11082. This is a felony. The maximum penalty, ma'am, is 20 years in prison and or $5,000 in fines. A consecutive sentence may be imposed for any other conviction rising out of the same transaction. There's a count 2 of assault with a dangerous weapon, also known as felonious assault. It's alleging that you did make an assault upon a Shatia Walker with a dangerous weapon, to wit a crowbar, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. This is contrary to Michigan Compiled Law 750.82, and this is a felony with the maximum penalty being 4 years in prison and or $2,000 in fines. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Okay, so Ms. Horton, do you understand the charges that I just read and the maximum penalty that you're facing with each charge?
I understand. It never happened.
Okay, so I'll take that as a plea of not guilty, okay, ma'am?
Absolutely.
Okay.
It never happened.
Okay, so you have the right to remain silent. Anything that you say and anything that you put in writing can be used against you. You have the right to be represented by counsel. You are represented today by Ms. Donnelly for the purposes of your arraignment, but you have the right to have attorney appointed at the public expense if you are considered indigent. That means you don't have or don't make enough money to hire an attorney. You understand that?
Yes,
Okay. Is she requesting court-appointed counsel?
Yes, she is. She's requesting for this case, and I understand it, there is also a retail fraud third that she's getting arraigned on today. Yes.
We're gonna PR on that.
Okay.
She's gonna be PR'd on the retail fraud. Okay. Okay, so Ms. Horton, I'll note that you're requesting court-appointed counsel and that for the purposes of your arraignment, you're entering a plea of not guilty. Okay, so you have the right to be considered for pretrial release from custody. We'll discuss your bond at the end on this matter. You have the right to proceed to a preliminary examination within 21 days of today's date. At the time of your examination, ma'am, you have the right to have the prosecution establish their burden of probable cause. So they need to bring enough evidence to establish that there is sufficient probable cause that a crime was committed and sufficient probable cause to charge you as the defendant who committed the crime. If this matter is to proceed beyond that stage, this matter will be bound over to the circuit court. At the time that you're at circuit court, you have the right to have a trial, and you have the right to have a jury trial. And at the time of trial, you have the right to remain silent and not have silence be used to prove or implicate your guilt. You have the right to question or cross-examine any witness the prosecution is going to call. You have the right to call your own witnesses or present evidence you believe would further any defense to the charge. And then you have the right to be presumed innocent until proven guilty. And again, the prosecution at the time of trial needs to prove each element of the charge being brought against you or the charges being brought against you beyond a reasonable doubt. Do you understand those rights? And do you have any questions about those rights?
understand,
Okay.
understand.
Thank you, ma'am. We're currently scheduled for probable cause conference before Judge Stacia Buchanan. It's scheduled for June 3rd, 2022 at 8:30 in the morning. That's going to be via Zoom, okay?
Okay,
Then you have a preliminary examination before Judge Buchanan. That's in person at the courthouse, June 10th, 2022 at 8:30 in the morning. Did you get a notice to appear, ma'am?
I think so, yes,
Okay, and then your Zoom instructions are behind. I think that's what the yellow form is, okay?
okay.
What's your current home address?
3605 Maybell.
That's in the city of Lansing?
Yes, ma'am.
Okay, are you okay, ma'am?
No,
Are you
In a
into
lot of
physical
pain.
pain or are you
Yes,
having
I
some
am.
pain?
yes,
Okay. Okay, is it possible to get her a chair or something?
I had fell and ripped my groin, so
I go.
I could stand for a
Take a
long
seat,
time. Thank
Okay,
you.
thank you. No problem. What's your phone number?
It's 619-4689.
That's area code 517.
Yes.
Okay, are you currently employed, ma'am?
No, I was taking care of my grandmother. She just passed away. I've been taking care of her for 6.5 years now.
Okay, I understood that you said you were taking care of your grandmother and she just passed away. And then what else after that?
I have been taking care of her for 6.5 years now.
Okay, so you were her caretaker. That was what you did full time?
I did it, but I wasn't getting paid. I just did it because that was my grandmother.
Okay.
Nobody else.
It's disability, Your Honor.
Thank you. My condolences on your grandmother. I'll note her that you're currently on disability. Thank you, Ms. Donnelly. Are you currently on probation or parole, ma'am?
No, ma'am.
Okay. That's fine, Ms. Donnelly.
Thank you, Your Honor. Ms. Horton reports that she is from Lansing. She has her family here, her kids are here. As she reported that she was just taking care of her grandma for 6 years. And now she's still living in her home. Hopefully she can stay there. And her aunt is assisting with that. So she has stable housing. She did not know about these offenses. She reports that she does not live with the complaining witness. And quite honestly would rather have no contact with her. So she's got no problems with the conditions that would be set. The only issue being is her financial situation. You know, she receives Social Security and disability, so she's on a fixed income. So given her connection, her ties to the area, and hopefully the standard conditions could apply, I was hoping that she could get a personal cognizance bond. But if it's not possible, Your Honor, just some reasonable 10%. Thank you, Your Honor. Also, I forgot. She reported that she had a pulled groin. She should have an appointment. She thinks she has an appointment for that on Monday, but her arm is broken in 3 places as well.
Have you ever missed court in the past, ma'am?
No, I haven't gotten in trouble. I don't know how long. I'm just usually a homebody.
You said, I didn't hear what you said. You said you haven't missed
No.
court?
No, not that I know of. I haven't gotten in trouble and I don't know when, because I'm a homebody. I'm always at home.
Okay, well, I know you've been before the court a lot. There's pretty
Yeah, in
extensive
the past.
criminal history here. Doesn't
Yeah.
appear that you've been before the court for a few years. I think the last time you probably were before the court was 2019.
Yeah, in the past.
Okay.
I've just changed tremendously.
Okay, well, these are some very serious allegations, and one of these allegations does carry a penalty of up to 20 years. And there are allegations of assaultive behavior. I'm going to grant the request for a personal recognizance bond. However, it will be with GPS tether and victim notification, okay?
Okay,
So while out on bond, ma'am, you're not to have any contact directly or indirectly with Shatia Walker. Do you understand that?
no problem. I just would like to
You're not to
say,
be, you're not to be within 1,500 feet of wherever Shatia Walker is. Do you understand that?
yes, ma'am.
Okay. You need to make sure you appear to court on time. You're not to engage in any sort of assaultive or threatening behavior.
No,
You're not to travel outside the state without prior approval of the court. You're not to
Okay.
purchase or possess a firearm or any other dangerous weapon while out on bond. You understand that?
Oh. Yes, ma'am.
You also need to report to pretrial services within 48 hours. You'll be reporting to them weekly, okay?
Okay,
You're not to use, purchase, or possess any drugs or alcohol unless you have a valid prescription. Do you have any questions about your bond conditions at all, ma'am?
no, man. Just wanna go home, be with my grandbabies.
Okay, and I think there was another matter, but my understanding is that was a retail fraud, so you'll get a personal recognizance bond, interim bond on that. Any additional matters for the record?
One, your honor, the exclusion zone on the GPS tether, is there an affidavit or on the complaint? Will it be the address on the complaint that is exclusion zone? I only asked that because she's gonna be held on, if she's gonna be held and not given a tether if they can't figure out what the exclusion zone's supposed to be. So I'm just making sure if there's any indication that they're gonna, that it might be like the prosecutor's job to figure out where the complaining witness lives.
Right,
Well,
Because,
my
like-
understanding is that there's at the address of 918 Pierce.
That's right. Okay, so that's where you believe that she lives, Miss Horton, right?
no,
Okay, so yeah, that should be fine then. Thank you, Your Honor.
No problem. Any additional matters for the record?
No, Your Honor.
Okay, you're all set, ma'am.
Shatia doesn't live there anymore.
I didn't hear you.
What was the
2,000
charge?
on a personal, 2,000 personal recognizance.
Thank you.
Thank you.
She was,
Do you know where she lives, Miss Horton?
actually, she stayed with me, and then she stayed with other people. She's been roaming around terrorizing everybody, so I don't know. But up the street from me, her grandmother died last weekend, so she's been
Okay,
living
so-
like.
So,
2 blocks
so
away.
it's all right,
I'm
Miss
gonna
Horton, that's
stop
all right.
you.
Yeah. So
I'm
yeah,
gonna stop you, because I think you're giving a little bit more information the court needs to hear. Nonetheless, that's the address of the alleged incident. It was the address that was made aware to the court as where the victim lives. If for some reason that doesn't become that address, then we can address her bond at another time, okay?
all right, thank you, Your Honor.
Thank you. You're all set, ma'am.
Thank you. Oh.
Michael Wayne Ganaway.
Oh, I'll wait. Keep going, keep going, keep going.
Thank you. We're on the record in the matter of the people of the state of Michigan versus Michael Ganaway, file number is 21-03358 SM. Counsel, can I have your appearance, please?
Thank you, Your Honor. Assistant Public Defender Sarah Donnelly on behalf of the defendant who's appearing from Lansing Police Department for the purposes of arraignment.
Thank you. And Mr. Ganaway, is that your name?
Yes, ma'am.
Thank you. Today's the date set for an arraignment for a bond violation. I have here a complaint of violation of conditional release, also known as a PA 53. It alleges that you violated the terms of your conditional release from custody by making contact with a Clifford Smith at 1401 West Holmes Road, which would be in violation of order issued by Judge Ward at the time of your arraignment back on December 12, 2021. So you have the right to have a contested hearing on the violation. You have the right to be represented by counsel at that hearing. If you're found to be in violation of the court's order, you can face contempt of up to 93 days in jail or up to $7,500 in fines. You understand that?
Yes, ma'am.
Okay, looks like you're already scheduled for a jury trial on this matter on July
Your Honor,
11th,
sorry.
2022 at 8 o'clock in the morning.
Your Honor, those charges are supposed to be just,
Yes, Your Honor, we're talking about case 21-03358, correct?
That's correct.
Okay, yes, it's my understanding. I don't know if it's been, I don't think it's been happened yet, but he entered into a plea agreement on, he pled in mental health court before Judge Hillman on Thursday. It was the prosecutor's agreement that if he pled guilty in that file, that they would dismiss this file. It's our understanding that it was dismissed, but it might not have officially been dismissed yet.
It's not dismissed.
Yes, that's my understanding, yes.
And the allegation is that he violated his bond conditions yesterday. So.
Yes, because I believe that this case hasn't been officially dismissed.
It would be up to the judge if they're going to dismiss it before addressing their bond violation, because it's still a violation of a court order.
Yeah.
And so I recognize you won't be having a trial, but that doesn't do anything with the bond violation. There's still an allegation of a bond violation. So the matter will be set for a hearing on the bond violation, okay? Unless you want to plead guilty to the bond violation today. Ms. Donnelly?
No, he would be pleading not guilty, Your Honor. Thank you.
Oh, thank you. The court will enter a plea of not guilty for the bond violation, and the matter will be set for hearing on the bond violation. You want to address bond?
Thank you, Your Honor. As reported, he was sentenced into mental health court on Thursday. I believe that there might have been some confusion about the cases, and if Hillman kept in place the no contact order on Thursday. I believe that's where some of the confusion lay in. But as an understanding that this was part of a plea deal, and he might not have to face in the end a PA 53 on this. I know that he is from the area that he is been reporting to court and not missing. So for those reasons, Your Honor, if at all possible, personal recognizance bond, but if not, a reasonable 10%. Thank you.
Thank you. That's it. You're not aware if Judge Hillman continued the no contact order as part of this sentence?
ma'am,
the mental health court on a domestic violence?
The
I wasn't
case is
aware.
not in, Mr., okay, just hold on, Mr. Ganaway. The case is not present on the 55th Register of Actions yet, so no, I wasn't able to confirm with the court or online whether that was a part of his condition. It's Mr. Ganaway that reported that Judge Hillman did not continue to no contact when he was sentenced on Thursday.
Okay.
It looks like on May 17th, he had a warrant for also a bond condition violation because he didn't show up. So, and that files 2 bond condition violations.
Okay, let me see. if there's a- I only see one here.
I only wrote 1 file, but you'll see a cancellation for the warrant for the bond violation. And then the new one, you'll see the paperwork.
Okay, sounds good. Okay, there is another, well, in this file, it already has a PA 53 pending, but that's from January. Looks like it just got adjourned out multiple times, likely due to the underlying screening and plea at mental health court. So I'm not sure how the judge is going to handle these. Because at this point, it would be at least 2 pending attached to this file, as at least that's what I see. And so Mr. Ganaway, I don't know what the order of the 55th District Court was, but I'm going to remind you that until and unless this case is dismissed, and if there is no, and if there is a no contact order over at the 55th, you need to comply with that. You can't
Yes,
live
ma'am.
or be around the alleged victim. Do you understand that?
Yes, ma'am.
Where are you planning to stay?
At the mission,
Like 430 North Larch?
no, I think it's 601 Michigan Avenue. Or 6 something Michigan Avenue, the rescue. mission. 630 something, maybe.
Okay.
607.
607.
Issue a bond in the amount of $500 personal recognizance to remind you of the no contact order with the alleged victim in this matter
Yes,
being
ma'am.
Clifford Smith, okay?
Yes, ma'am.
You're also not to be at the address of 1401 West Holmes Road. Or within 1,500 feet of wherever the
Yes.
victim lives, works, or goes to school. Do you have any questions?
No, Your Honor.
Any additional matters for the record, counsel?
No, Your Honor.
Okay, you're all set, sir. Joshua Isaac Ferguson. On the record, in the matter of the people of the state of Michigan versus Joshua Isaac Ferguson, file number 22-01232 SM. Council appearance, please.
Assistant Public Defender Sarah Donnelly on behalf of the defendant who is appearing from Lansing Police Department for the purposes of arraignment.
Are you Joshua Isaac Ferguson?
Yes, ma'am.
Okay, thank you. Mr. Ferguson, today's the date set for arraignment on a bond violation, and I have before me a complaint of violation of conditional release, which is also known as a PA 53. It alleges that you violated the conditions of your bond, which state that you are not to have direct or indirect contact with the Monet Thomas, and you're not to be within 1,500 feet of wherever she lives, works, or goes to school. The allegation is that you violated those conditions today. And so you have the right to have a contested hearing. You have the right to be represented by counsel during the contested hearing. If you're found to be in violation of your bond conditions, that's considered a contempt of court, punishable with a maximum penalty of 93 days in jail and up to $7,500 in fines, okay?
Yes, ma'am.
I don't have the original file here, so I couldn't tell you what your next action date is. You know if he has an attorney on the underlying matter?
Yes, Your Honor, he does have our office.
Okay. For the purposes of his arraignment on the PA 53, how does he want to plead?
He'll plead not guilty.
Okay, this matter will be set for a hearing. You'll get the notice in the mail. What's your address, sir?
430 North Larch.
Okay. You want to address the bond, Ms. Connolly?
Thank you, Your Honor. Mr. Ferguson reports that he is staying between the Holy Cross Shelter and the Rescue City Mission. He is working, he works at McDonald's. He was going to stay at a cousin's house, so he has family in the area. The issue with him is that he and the complaining witness in the case share a small child, a 2-year-old son, that he it's been a very long time. He reports he hasn't seen him in quite some time because I believe he's also on probation. I don't know if there is a hold for that because I do believe it is still concerning the same complaining witness. So I don't know if there is a no contact or any sort of bond violation in that, but he says that he doesn't have, basically they sound like they're both not very social. They don't have any friends, and the only family, I believe he also is her mother, that he also, I believe, does not have not able to contact. So so the issue is that he wanted to see his son. And he had no other way to do it. So that it was just for that, I believe it was just for that reason, Your Honor. So for that, I was going to request a reasonable bond. Thank you.
Okay, looks like back on May 12th, 2022, less than 10 days ago, Mr. Ferguson was arraigned by Magistrate Milmore. She said that there was a no contact order, that Mr. Ferguson could not be within 1,500 feet of wherever Ms. Thomas was, but also could not have contact directly or indirectly with her. And that doesn't mean that if he had what he or his attorney believes was a good reason, that he could violate that. So you're not to be at her house, you're not to be in communication. The allegations of the violation also include allegations of threats made to the alleged victim. And so the court is of the mindset that there is a threat to the public safety at this time, and that Mr. Ferguson has no intention of following the court's order. Personal recognizance bond will not be granted. Bond in the amount of $2,500 cash surety is issued. I'll remind you of the no contact order. You're not to be in any contact directly or indirectly with Ms. Thomas. This court doesn't handle family matters. If you have a concern about seeing or making arrangements with seeing your child, you need to go before the family court, and you don't get to violate the court's order and make your own order. Do you understand that?
Yes.
Or other bond conditions as previously set by Magistrate Milmore will continue. Do you have any questions about your new bond, sir?
I had a question. How, you said it was threats made? Like, I don't know where you get threats from.
I'm sorry, I didn't hear what you said.
You said something about.
Mr. Ferguson, that's not a matter for today. Whether there was threats or not, that's just what she has in front of her. That's, she doesn't know any more than that.
Oh. Any questions for the court, sir?
Nope.
Okay, you're all set. Thank you.
I don't like it.
Troy Allen Davis. Are you Mr. Foy Allen Davis the third?
Yes, ma'am.
Okay, we're on the record in the matter of the people of the state of Michigan versus Foy Allen Davis the third. The file number is 22-000009FH. Council appearance.
Thank you, Your Honor. Assistant Public Defender Sarah Donnelly on behalf of the defendant, who is appearing from Lansing Police Department for the purposes of arraignment only.
Today's the date that I'm set for arraignment, Mr. Davis, for a PA 53 violation, also known as a violation of your conditional release or your bond conditions. I have here a PA 53 alleging that you violated the conditions of your bond by making contact with the Heather Olson or being within 1,500 feet of wherever she lives, works, or goes to school. And so you have the right to have a contested hearing on the alleged violation. You have the right to be represented by counsel during that hearing. If you're found to be guilty of violating your bond conditions, sir, you're facing a contempt of court order, and that's punishable with the maximum penalty of 93 days in jail or up to $7,500 in fines, okay?
Yes, Your Honor.
I believe this matter might already be bound over. I could be wrong, though. It appears that this matter may be bound over to Judge Jamal already. Is that
Yes, Your Honor,
information
that's
you
my
have?
understanding. Yes.
Okay. Okay, so for the purposes of his arraignment, is he pleading not guilty?
Yes, Your Honor.
And he has counsel on that matter?
Yes, Your Honor.
Okay, so this matter will be set for hearing. You'll get a notice in the mail. What's your address, sir?
My address as of right now is 2520 Artisan, ARTISAN Drive. That's Lansing, Michigan, 48910.
Are you currently employed?
Yes, I am, ma'am.
Where are you working?
I work for a family business. It's called Global International. We do landscaping, lawn care, and snow removal.
Okay, did you want to address bond?
Thank you, Your Honor. As Mr. Davis reported, he is fully employed for his family business. He is from the area. He is currently undergoing cancer treatment. I don't know if you can tell, but some melanoma tumors on his face. He's trying to shrink them with radiation medication that he's taking in order to have surgery. And he doesn't have that radiation. He doesn't have his medication with him. I believe that's a good reason that he remain out of jail. Besides that, I believe this is a misunderstanding about the conditions. He understands now that it includes where she lives. They share a 15-year-old daughter. She needed a ride to school, and so he, assisted his daughter that morning. But it's my understanding that his spouse was not there. She was already, basically a family issue, you know, she gets a new job, daughter has to go to school. And unfortunately, Mr. Davis, you know, the no contact order, precluded him from going there, which I believe he didn't know if that was, the case. So, for those reasons, Your Honor, I don't believe there's a flight risk. I don't believe that there's any increased danger. So we would ask for a personal recognizance bond or a reasonable 10%. Thank you.
I'm not understanding how there is any confusion about an order that very clearly states no contact with Heather Olson or be within 500 feet of where she works, lives, or goes to school.
I know that it's made very clear, Your Honor. I do. I understand. And I know that that's what was given across to Mr. Davis. I don't know where the disconnect was, but that's just how he explains that he didn't know that was it was his understanding that he couldn't be around his wife, but yeah, or his ex-wife, sorry.
Okay, well, I think the allegations, at least as alleged in the PA 53, say the complete opposite, that he knew he wasn't supposed to be there, nonetheless, and that he had no family and nowhere to go. So that's the concern of the court, is that when you know there's an order and you understand the order and you continue to violate it. I'm going to grant the request for a personal recognizance bond, but there will be GPS tether added with victim notification. Bond will be set at 500 personal recognizance with GPS tether. I'm going to remind you, sir, and I'm going to clarify, you can't have contact directly or indirectly with the alleged victim, Heather Olson. Do you understand that?
Absolutely, Your Honor.
You cannot be within 1,500 feet of wherever she lives, wherever she works, wherever she goes to school. Even if she's not
Understood.
there, you can't be at that address. Do you understand that?
Yes, ma'am.
Any additional matters for the records?
No, Your Honor, thank you.
Thank you. You're all set, sir.
Thank you, Your Honor.
You're welcome. Bernard Winslow Jones. Bernard Winslow Jones.
Yes, ma'am.
Okay. Okay, we're on the record in the matter of the people of the state of Michigan versus Bernard Winslow Jones. I'll take file number 19-00868 FY first, council appearance.
Thank you, Your Honor. Assistant Public Defender on behalf of the defendant who is appearing from Lansing Police Department for the purposes of arraignment only.
Okay, Mr. Jones, on this particular matter, you're on probation before Judge Stacia Buchanan. You were scheduled to have a probation violation hearing via Zoom on February 23rd, 2021. You failed to appear. What happened?
God, I never received anything from the courts. They didn't give me no paperwork stating that I'm supposed to have did that. I haven't gone down to the probation office when I was supposed to report. I paid my fines, but I'm supposed to pay it. They said they would send me a letter, and they never did. I never received anything. The only thing they told me I had to
I
do was
had
run
a
in.
feeling you'd say that because it looks like when you didn't show up for your arraignment, you gave that same excuse that you
For my
didn't get
arraignment.
any information. But they would have given you your notice or your date for your hearing at the time of your arraignment, which was on January 12th, 2021. And you
I
did
went
not
there.
appear, sir. And you knew you were on probation, correct?
Yes, ma'am.
Okay. So this matter will be set for a new hearing date. What's your address?
1317 East Kalamazoo. Apartment 15.
Apartment 58,
15.
15.
Yes, ma'am.
What's your phone number?
214-9568. I think she got the yellow.
Area code is 517.
Yes, ma'am.
Okay, now on the matter of the people of the state of Michigan versus Renard Jones, file number 21-01899FY. Okay, Mr. Jones, I have here a felony complaint. It alleges that on or about February 11, 2021, at the area of 1317 East Kalamazoo, Apartment 15, City of Lansing, Ingham County, State of Michigan, that you did allegedly in count 1 commit the act of domestic violence. It alleges that you did make an assault or an assault and battery upon a Trina Kuthin, an individual with whom you had a dating relationship, and that this was done contrary to Michigan Compile Law 750.812. Restitution may be ordered as this offense may have resulted in damage to another individual's property or physical injury or death to another individual. That's a misdemeanor with a maximum penalty of 93 days and or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There's a third offense notice. It says, take notice that the defendant was previously convicted of assaulting or assaulting and battering his or her spouse, former spouse, an individual with whom he or she had a dating relationship, an individual with whom he or she had a child in common, or a resident or former resident of his household, or of knowingly assaulting a pregnant individual by violating Michigan Compile Law 750.812 on or about December 4th, 2013, and by violating MCL 750.812 on or about July 16, 2013, and therefore upon conviction will be subject to an enhanced sentence under MCL 750.815 that would make the domestic violence a felony. Maximum penalty 5 years in prison and or $5,000 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There's a count 2 of assault with a dangerous weapon, also known as felonious assault. It alleges that you did make an assault upon a Trina Kuthin with a dangerous weapon, that being a stick, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder, and that this was done contrary to Michigan Compiled Law 750.82. As a felony with a maximum penalty of 4 years and or $2,000, DNA is to be taken upon arrest, and a consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. There's an habitual offender notice here. Third offense notice, it says take notice that the defendant was twice previously convicted of a felony or attempt to commit a felony, in that on or about April 18, 2018, he was convicted of the offense of tampering with an electronic monitoring device in violation to MCL 771.3F in the 30th Circuit Court, Ingham County, State of Michigan. And on or about August 10th, 2016, he or she was convicted of the offense of tampering with an electronic monitoring device in violation of MCL 771.3F in the 30th Circuit Court, Ingham County, State of Michigan. And therefore, upon conviction, the defendant is subject to penalties provided by MCL 769.11, making the penalty twice the maximum sentence on primary offense or a lesser term. The maximum penalty cannot be less than the maximum term for a first conviction. Do you understand the charge there and the maximum penalty associated with that charge?
Yes, ma'am.
I also have here the people of the state of Michigan versus Raynard Winslow Jones. It alleges that on or about May 20th, 2022, at the area of 1317 East Kalamazoo Apartment 15, City of Lansing, Ingham County, State of Michigan, that you did allegedly contrary to law commit the act in count 1 of domestic violence. It alleges that you did make an assault and battery upon a Trina Kuthin, a resident or former resident of your household, or an individual with whom you had a dating relationship. This was done contrary to Michigan Compiled Law 750.812. Restitution may be ordered, as this offense may have resulted in damage to another individual's property or physical injury or death to another individual. The maximum penalty is a misdemeanor, 93 days and or $500 in fines. However, there's a third offense notice. It says take notice that the defendant was previously convicted of assaulting and battering his or her spouse, former spouse, an individual with whom he had a dating relationship, an individual with whom he had a child in common, or a resident or former resident of his household, or by knowingly assaulting a pregnant individual by violating Michigan Compiled Law 750.8182 on or about July 12, 2012, and by violating MCL 750.812 on or about July 16, 2013, and therefore upon conviction will be subject to enhanced sentence under MCL 750.815. The maximum penalty for this domestic violence, if convicted, would be 5 years and or $5,000 in fines. A consecutive sentence may be imposed under the law, and restitution may be ordered in this matter, as this matter may have resulted in damage to another individual's property or physical injury or death. So, sir, these are two separate files, but do you understand the charges read in both and the maximum penalties in each?
Yes, ma'am. I understand you're saying something with some pregnancy, but I don't know about that.
I'm sorry, sir. I didn't hear you. Can you repeat that?
You said something. something about some pregnancy or something?
No, that's just, it said that you knowingly assaulted someone that you was either one of these categories. It could have been a spouse, a former spouse, someone you
Okay.
lived with or was in a dating relationship, or it could have been a pregnant person, or someone you had a child with. You got
I
that?
understand. Yes, ma'am.
Okay. So do you have any other questions about the charge and the penalties associated with these charges?
No, ma'am.
Okay, and so you have the right to be represented by counsel on each of these files. You're represented by Ms. Donnelly today for the purposes of arraignment only, but you have the right to have an attorney with you to represent you at each stage of the criminal prosecution. If you are indigent, you can apply to have court-appointed counsel to represent you at the expense of the public. Is he requesting court-appointed counsel?
Yes, Your Honor.
Okay, Mr. Jones, you have the right to remain silent. Anything you say and anything you put in writing can be used against you. You have the right to plead guilty. You have the right to plead not guilty, and then you have the right to stand mute and proceed with the criminal prosecution. In each of these new files, because they are a maximum felony conviction, you have the right to proceed to preliminary examination within 21 days of today's date. At the time of your examination, you have the right to have the prosecution bring sufficient evidence to establish their burden of probable cause. So they have to establish in each of these files that there's sufficient probable cause that a crime was committed and sufficient probable cause to charge you as the defendant who committed the crime. Do you understand that?
Yes, ma'am.
File number 21-01899FY, you're currently scheduled for probable cause conference before Judge Tony Flores on June 2nd, 2022 at 9 o'clock in the morning. And then you have a preliminary examination before Judge Flores. That's going to be in person at the court on June 10th, 2022 at 9 o'clock in the morning. And then on the other file that I don't have a file number for yet, you have a probable cause conference before Judge Stacia Buchanan. It's going to be on June 3rd, 2022 at 8:30 in the morning. That's via Zoom. And then your preliminary examination before Judge Buchanan is going to be in person at the court, also on June 10th, 2022 at 8:30 in the morning. Did you get 2 notices to appear, sir?
Yes, ma'am.
Okay. You have the right to remain silent. Anything you say and anything you put in writing can be used against you at the time of trial. If these matters are to proceed beyond the preliminary exam stage, you have the right to have a jury trial in circuit court on these. You also have the right at the time of trial to remain silent, not have silence be used to prove or implicate your guilt. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecution prove each element of the charges being brought against you beyond a reasonable doubt. You have the right to question or cross-examine any of the witness the prosecution intends to call. And then you have the right to call your own witnesses or present evidence you believe would further defense to the charge. You also have the right, sir, to be considered for pretrial release from custody, and we'll address your bond in just a moment. For the purposes of his arraignment today, is he pleading not guilty in both files?
Yes, Your Honor.
Okay, so you previously gave me an address that you're not going to be able to reside at during the pendency of these matters, so I need a new address.
430 North Lawrence.
I'm sorry?
430 North Lawrence.
Okay.
Currently in the management office.
Are you currently employed?
No, ma'am.
Are you currently on probation or parole?
No, ma'am.
Well, he's on the current,
You
with the current
You
probation.
are on probation. You're on probation. I did
Oh, yeah, she said that.
say you're gonna have a violation hearing on a file that's pending on probation, but you're not on parole at this time?
No, ma'am. Completed.
You can address bond.
Thank you, Your Honor. Mr. Jones reports that he's legally blind. He does have a walk with a cane because of a bad back, and he does take medications for his seizures. He's not working, but he is from the area. He has family here. For those reasons, we would request either a personal cognizance or some other reasonable cash bond. Thank you, Your Honor.
Okay, so I have before me 3 files here, 2 of which have allegations of assault being charged as a third offense. And then I have 1 file where Mr. Jones was supposed to be before the court in 2021, February 2021, and failed to appear after another failure to appear where he's supposed to be in January 2021. So I think there's both concerned about his likelihood of returning to court, because that's evidence by the first file we arraigned him on, that he doesn't keep up with his court dates. But also, I believe that there is a risk or some risk to the public, mainly the victim in this matter. So I have a concern about releasing him on his own recognizance, because his own recognizance hasn't required or brought him back to court in the past. The court will issue bond and file number ending in 1899 in the amount of 5,000, 10% with GPS tether. And that will be with victim notification. So you're not to be within 1,500 feet of wherever the alleged victim, Trina Kuthin, lives, wherever she works, wherever she goes to school. Do you understand that?
Yes, ma'am.
You're not to have any contact or any communication with her at all of any kind. That's direct contact or indirect contact. You know what indirect contact means?
Yes, ma'am.
Can't have anybody else contact her on your behalf. You can't contact her via social media or by any other means. Do you understand that, sir?
Yes, ma'am.
You need to make sure you appear to court for all your future court dates. You're not to engage in any assaultive or threatening behavior while you're out on bond. You're not to use, purchase, or possess alcohol or drugs unless you have a valid prescription for the drug. Do you understand that?
Yes, ma'am.
not to purchase or possess a firearm or other dangerous weapon, not to travel outside the state without prior approval of the court, need to report to pretrial services within 48 hours of your release. You'll be reporting to them weekly. On the other file, there will be a bond of 5,000, 10% as well. Same conditions on that bond. Do you have any questions?
No.
And
Hold
then
on, Mr. Jones.
I'm sorry, I'm not finished. I haven't given you a bond on your violation for probation, okay? I'll issue a personal recognizance bond on that matter, okay? Do you have any questions?
Yes, ma'am. You said,
What's your question?
5,000 on each bond.
Okay, file number 19-00868. That's the one that you were on probation on, sir. I'm going to issue a bond for 500 personal recognizance on that one, okay?
Okay.
Now, the other two files where you have, one is file number ending in 0189, domestic violence, third offense, and felony assault. That one is gonna be 5,000, 10% with GPS tether. The other file, I do not have a file number, but that's also a domestic violence, and that's gonna be 5,000, 10%, okay?
Okay. One other question. I don't have any money to bond on. The only thing I get is food stamps.
What is the question?
I said, I don't have any money to bond out. The only thing I get is food stamp. So how could I pay 500 but I can't pay $50?
Okay, that sounds like more of a statement, sir. It's not a question. You saying you don't have any money is just indicating that you're not able to make these at this time. But my bonds are not set based on your ability to pay them. It's based on some things that I had to take into consideration, which includes safety to the community, as well as your likelihood to return to court. You've demonstrated that you don't return to court, because I have to arraign you on a file that you've not been before the court and the bench warrant had been pending for over a year. And then I have two files, additional files, where you have 2 counts of domestic violence, third offense notice, and 1 felonious assault being charged. And it all should be indicated that this is probably one of the thickest criminal histories I've ever had to review during an arraignment.
Okay, I have one other question.
Okay, I'm waiting.
It was going, you said it was, benchmark was out for a year and I've been over there for 3 years. Why haven't I received it? That's what I'm asking. Why haven't I received it?
I can't answer that question for you, sir. I can't answer why you weren't aware that you had a bench warrant, but I do know that you knew that you pled guilty and you were sentenced to a term of probation. I do know that you did appear for the arraignment for the violation. So have a good day.
Yeah, you too.
So that's all I have, or I have one more.
3 years and you can't bring me a warrant. Well, like, courts can fuck up, but yet still, I'm supposed to just. Man,
Question. Question. Thank you, Hannah.
Okay, this is Anthony Bernard Kristen.
Yes, Your Honor.
Are you Anthony Bernard Kristen?
Yes, Your Honor.
Okay, I have 2 files here. for on the record in the matter, the people of the state of Michigan versus Anthony Bernard Preston. Can I? Counsel appearance, please.
Assistant Public Defender Sarah Donnelly on behalf of the defendant who is appearing from Lansing Police Department for the purposes of arraignment only.
Okay, again, I have two files. The first file I'll take is the misdemeanor complaint. Sir, it alleges here that on or about May 20th, 2022, at the area of 824 Conrad Avenue, apartment C5, City of Lansing, Ingham County, that you did allegedly contrary to law commit the act in count 1 of domestic violence. It alleges that you made an assault or an assault and battery upon a Karen Stone, a resident or former resident of your household, or an individual with whom you had a dating relationship, and that this was done contrary to Michigan Compiled Law 750.81. 2, restitution may be ordered as this offense may have caused damage to another individual's property or physical injury or death to another individual. That's a misdemeanor with a maximum penalty of 93 days in jail and or $500 in fines. A consecutive sentence may be ordered if the assault was committed in a place of confinement. There is, however, a second offense notice here. It says, take notice that the defendant was previously convicted of assaulting or assaulting and battering his or her spouse, former spouse, an individual with whom he or she had a dating relationship, an individual with whom he or she had a child in common, or a resident or former resident of his household, or of knowingly assaulting a pregnant individual by violating MCL 750.812 on or about March 12, 2001, and therefore upon conviction will be subject to an enhanced sentence under MCL 750.814. That would make the maximum penalty still a misdemeanor, but punishable up to 1 year and or $1,000 in fines. Again, a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. The other file I have has a felony complaint here. This one alleges that on or about April 13, 2022, at the area of 824 Conrad, apartment C20, City of Lansing, Ingham County, State of Michigan, that you did allegedly in count 1 commit the act of larceny from a person. It alleges that you did commit the offense of larceny by stealing from the person of another, that being a Karen Stone, certain property to which was a cell phone, and that this was done contrary to MCL 750.357. It's a maximum penalty of 10 years in prison. There's a count 2 of domestic violence, and that alleges that you did make an assault or an assault and battery upon Karen Stone, an individual with whom you had a child in common, or a resident or former resident of your household, or an individual with whom you had a dating relationship, contrary to MCL 750.812. Restitution may be ordered as this offense may have resulted in damage to another individual's property or physical injury or death to another individual. The penalty here is a misdemeanor, 93 days and or $500 in fines. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There is also a second offense notice here as to the domestic violence, and it states, take notice that the defendant was previously convicted of assaulting or assaulting and battering his or her spouse, former spouse, an individual with whom he or she had a dating relationship, an individual with whom he or she had a child in common, or a resident or former resident of his or her household, or of knowingly assaulting a pregnant individual by violating MCL 750.812 on or about March 12, 2001, and therefore upon conviction will be subject to enhanced sentence, making the misdemeanor punishable with a maximum penalty of 1 year and or $1,000 and fines. There's an habitual offender third offense notice. It states here, take notice that the defendant was previously or twice previously convicted of a felony or attempt to commit a felony, and that on or about June 18, 2014, he or she was convicted of the offense of larceny in a building in violation of MCL 750.360 in the 30th Circuit Court, Ingham County, State of Michigan, and on or about February 3rd, 2011, he or she was convicted of the offenses of retail fraud, first degree, in violation of MCL 750.356C in the 54A District Court for Ingham County, State of Michigan. Therefore, defendant is subject to penalties provided by Michigan Compiled Law 769.11. The penalty will be enhanced to twice the maximum sentence on primary offense or a lesser term. The maximum penalty cannot be less than the maximum term for the first conviction. The court shall also order law enforcement to collect a DNA identification profiling sample before sentencing or disposition if not taken at arrest. Do you understand the charges read in each file, sir, and the maximum penalty for each file?
Yes, Your Honor.
Okay. You have the right to be represented by counsel on each of these files. You do have representation today from Ms. Donnelly from the Public Defender's Office, but it's only for the purposes of your arraignment today. If you are indigent, you can request to have an attorney represent you because you have the right to have an attorney to represent you at each stage of the criminal prosecution. Do you understand that?
Yes, Your Honor.
Is he requesting court-appointed counsel on these files?
Yes, he'd be pleading not guilty and requesting court-appointed attorney.
Thank you. Hey, Mr. Kristen, you have the right to remain silent. Anything you say and anything you put in writing can be used against you. You have the right to plead guilty. You have the right to plead not guilty. And you have the right to stand mute for the purposes of your arraignment as indicated by Ms. Donnelly. The court will enter a plea of not guilty on your behalf. You have the right to have representation with you at all stages of the criminal prosecution, which would also include if you are questioned or interrogated during this prosecution. You also have the right to proceed to a preliminary examination in the felony file. You have the right to have that examination within 21 days of today's date, which is the date of your arraignment. At the time of your examination, you have the right to have the prosecution bring sufficient evidence to establish the burden of probable cause. So they need to bring evidence to prove that there's sufficient probable cause that a crime was committed and sufficient probable cause to charge you as the defendant who committed the crime. You understand that, sir?
Yes, Your Honor.
In both files, you have the right to proceed to trial in this matter, and you have the right to have a jury trial. At the time of trial, you have the right to remain silent and not have silence be used to implicate or prove your guilt. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecution bring sufficient evidence, as it is their burden to prove each element of the charges being brought against you beyond a reasonable doubt. And you have the right to question or cross-examine any of the witnesses that they call at trial. And you have the right to call your own witnesses or present evidence at trial that you believe would further a defense to these charges. Do you understand your trial rights, sir?
Yes, Your Honor.
In the felony file, you're currently scheduled for probable cause conference before Judge Tony Flores on June 6, 2022 at 9 o'clock in the morning. You have preliminary examination before Judge Flores in person on June 10th, 2022 at 9 o'clock in the morning. On the misdemeanor file, you're currently scheduled for pretrial conference before Judge Stacia Buchanan on June 6, 2022 at 10:30 in the morning. Did you get your notices for each of those?
Yes, Your Honor.
Are you currently employed, sir?
No, I'm not, Your Honor.
What's your home address?
A home address, 2385 Cedar Park Drive. Apartment 325. Hope, Michigan.
Cedar Park
Cedar-
Drive.
Yes.
Apartment, what again?
Apartment 325,
Okay, it's in Lansing,
no, Hope, Michigan,
Holt.
48842.
What's your phone number?
Phone number is 517-894-4079.
How do you support yourself, sir?
I get disability. I'm blind in one eye and my left eye, and I got glaucoma.
Are you currently on probation or parole?
Your Honor.
Was that a no?
No.
Okay. You can address bond, Ms. Donnelly.
Thank you, Your Honor. Quick question. Are we addressing also the failure to appear case 1337-21 from 2021?
I don't have it. Was it for
Okay.
retail fraud?
An assault on a battery and a retail fraud third that he had a failure to appear for sentencing on before Judge Buchanan, August of last year.
That's all I have. Does the jail have another file?
He had trespassing and he just had a failure to appear, doesn't say for sentencing. What was the case number?
21-01337 SM.
It just says failure to appear down here and it's got a $3,000 bond. So we were gonna PR him on it.
That's
Well,
it for sentencing? That's the one that he failed to appear for sentencing in 2001?
No, 2021, Your Honor, August of last year.
It does not say that down here on our end. It just said failure to appear.
Okay, what was the charge on that?
It was an assault and battery and a retail fraud third.
So you're saying, Ms. Donnelly, that he pled guilty to retail fraud? Is that what it was?
He pled guilty to both, Your Honor.
Okay, I'll arraign him on him. I don't want to PR on it. Let me let you address bond on these.
It's a, like,
I thought it was just a trespassing, but if it's a failure to appear on an assaultive case.
No, he's been sentenced. It looks like maybe because the sentence tab is filled out. And issue.
Mr. And in fact, that Mr. Friesen reports that he did appear for that sentencing itself, but it just seemed like the ROA that it was sent to Judge Buchanan for review yesterday. But again, I don't have any official sentencing information.
Okay, sounds good. But he was not sentenced to probation? Mr. Person, you're not on probation or parole?
No, I'm not on probation or parole, Your Honor.
Okay, sounds good. And I'm not sure which matter you all are referencing, but what I see is a retail fraud and a assault and battery on his criminal history, but they both say nollied on it. So unless there's another one. Because this one was from 2021. I'm not sure, but I'll just handle these ones. You can address bond.
All right, thank you, Your Honor. Mr. Friesen is from the area. He, as he reported, he does have glaucoma and he's recently got disability for that about 9 months ago. He takes medications for it. He has regular doctor's appointments. And so given his financial status and his ties to the area, I would just want the court to consider that when setting bond. Thank you, Your Honor.
Okay, thank you. I would ask you if you've missed court before, but I think that's apparent by the fact that there may be a bench warrant that you're going to get PR'd on, sir. So I do have a concern about your willingness to return to court if you're on your own recognizance.
No, I will return to court, Your Honor.
Well, I still have a concern about the safety of the public, mainly the victim in this matter, Karen Stone. I have 2 pending matters, one with a second, well, both with a second offense notice. One from allegedly having occurred on April 13, 2022. Another one allegedly having occurred on May 20th, 2022. So I'll grant the request for a personal recognizance bond, but with GPS tether and victim notification. You're not to be within 1,500 feet of wherever Karen Stone lives, works, or goes to school. Do you understand that?
Yes, Your Honor.
Bond in each file will be $1,000 personal recognizance. No contact in each file, the same victim, but just in case there's any confusion, you can't have any contact directly or indirectly with Ms. Stone. Do you understand that?
Yes, Your Honor.
So you can't call, you can't have anybody else call or give a message on your behalf. Do you understand that?
Yes, Your Honor.
While on bond, you're not to engage in any assaultive or threatening behavior. You're not to use, purchase, or possess alcohol or drugs unless you have a valid prescription. You're not to travel outside the state without prior approval of the court. You're not to possess or purchase a firearm or other dangerous weapon. You understand that?
Yes, Your Honor.
You need to report to pretrial services within 48 hours. You're going to report to them once a week, okay?
Yes, Your Honor.
Okay, and with the GPS tether, there will be victim notification order. You're not to be at the address of 824 Conrad. I don't know if maybe the address changed or if there's an error. One file has an 824 Conrad apartment C4, the other one is C20. But you shouldn't be at either, okay?
Okay, Your Honor.
Because you're not to be within 1,500 feet of wherever the alleged victim is living. Do you have any questions?
No, Your Honor. Well, how do I do this tether thing? I mean,
You'll get that information from the jail, okay?
on this jail here.
Okay, do you have any other questions, sir?
No, I don't. Do I have to pay for the tether?
You do.
You can apply if you're, don't have enough money, they do have forms you can fill out to waive the cost.
Okay.
Do you have any other questions, sir?
No, I don't, Your Honor.
Okay. Any additional matters for the record, counsel?
No, Your Honor, thank you.
Thank you. You're all set, sir.
Thank you, Your Honor.
Thank you.